This is Nick Thompson in Louisville, Kentucky, a bankruptcy and foreclosure attorney. A lot of people come to me and they ask, well, why shouldn't I just do debt settlement instead of bankruptcy? Well, there's a lot of reasons why you don't want to do debt settlement. First of all, the idea is that Chapter 7 and Chapter 13 have much higher success ratios. About 99% of the people who file a Chapter 7 bankruptcy end up getting their discharge. The debt's gone. And about somewhere around 50% of the people that file as a Chapter 13 are able to complete their Chapter 13 and discharge the debt. The other 50% of the people that do not finish a Chapter 13 end up converting to a Chapter 7. So still, there's a relatively high, better, more than 50% success ratio of people who file bankruptcy, discharge the debt, and they get to put that debt behind them. However, with debt settlement, over 90% of the people who file debt settlement plans and that try to pay 50 cents on the dollar towards their debts never complete the plan and they go right back to owing all the debt. Second reason to use bankruptcy, debt settlement is taxable income. If you owe $100,000 and you file bankruptcy, your taxable income off of discharging that $100,000 of debt is zero. If you end up getting a debt settlement, and let's say you had $200,000 worth of debt, and you settled it for 50 cents on the dollar, you'd have to pay back first $100,000. You would get rid of $100,000 worth of debt, but now you have a $40,000 tax bill because they've sent in a 1099-C for the fact that you didn't pay them back in full, okay? And they get a tax break of $100,000 of lost income, and you now get that income that is charged to you. And now you get an IRS debt for what you discharged as debt. The third thing, debt settlement companies quite often file bankruptcy themselves. Look at the case of Ameridebt, where Ameridebt took in millions of dollars from people who paid them to settle their debts. The money largely went to the salaries of corporate officers, and then Ameridebt itself filed bankruptcy. This is the type of thing that happens with many debt settlement companies. And quite often, people end up being victims, whether they happen to be a debt settlement that they go through, or whether or not they tried to catch up their payments by paying a foreclosure rescue company. Quite often, the only people that get paid is the debt settlement company or the foreclosure rescue company. Your credit suffers both ways, whether you don't pay the debt through bankruptcy or whether you don't pay the debt through debt settlement. If it suffers both ways, why not use the more effective way, the bankruptcy way of discharging these debts? Another reason for using bankruptcy is many of these debt settlement companies are owned by banks or creditors. You call up the bank, you say, geez, I'm $20,000 behind, I'd like to settle the debt with you. They funnel you off to a company that the bank actually owns, and all the debts are put into that company, and the bank that owns the debt settlement company is the one that's paid the majority of the payments. The other creditors get paid little or nothing. And then at the very end of the period of time, and you go that you are in this debt settlement process, what happens quite often is people become disabled, they become sick, they go through a divorce, something happens to them. They're not able to make the payments. They're kicked out of the debt settlement process, and they go right back to owing everybody. The only person that got paid was the bank that you came to because they owned the debt settlement company. And you may not want to use that process. You may want to be aware of who actually owns that debt settlement company. Another thing, bankruptcy attorneys are often CPAs, or they're far more qualified than the person you're talking to at the debt settlement company. Debt settlement companies are often called the bill legal group. They pretend to have some authority that they don't have. Quite often, the person that you're talking to is just very good at selling debt settlement plans to people who call in. He may have little or no qualifications. He may have just gotten out of prison last week. He's very good at talking to people and talking them into things. But if you're wanting to talk to somebody who's a qualified financial planner, someone who's had a background in finance, accounting, somebody who's a CPA, you're far more likely to get quality financial advice out of a bankruptcy attorney than you are from somebody who is making $30,000 or $40,000 a year, and he worked for a debt settlement company. And last week he was installing Windows, but he's gotten to be very good at talking to people and selling them on debt management plans instead of Windows. Finally, you can't force debt settlement onto people. If I go to court and I file a bankruptcy, I have the power of a federal judge and a federal court order. If a creditor doesn't like the idea that I'm going to pay them back 10 cents on the dollar or 5 cents on the dollar, too bad. I have a federal judge that can force this upon the creditor. If I'm trying to convince a bank to take debt settlement, that creditor may or may not accept that offer. And if he chooses not to accept it, he doesn't have to. Another reason is that debt settlement companies often pay themselves first. You're paying into the debt settlement, and it's not until the second year or third year, quite often, that anything is paid towards your debts. You're paying them first. And if the plan fails, nothing was paid towards your debt quite often. This is just the way the system works. Another thing is Chapter 13s are modifiable. If you end up getting into a Chapter 13, your plan payments are $300 a month, you become sick. Well, you can choose not to simply make payments for 2 or 3 months. You can modify the Chapter 13. You do need to get in touch with your attorney. He does need to file a motion to amend the order of confirmation or a motion to amend the plan. You explain to the judge, well, I was making $100,000 a year, now I'm making $50,000 a year, and now I need to lower my plan payments. I need to lower the percentage that I'm paying the unsecured creditors. I need to skip 2 or 3 payments, or maybe I need to get an early hardship or early discharge from the Chapter 13. I've made the payments in for 3 or 4 years, but now due to no fault of my own, I'm now sick, I'm not able to complete the plan. I would like to get a discharge in my second year or fourth year of the plan and not have to complete 5 years. Because of your ability to modify the plan, you're able to make sure that that plan works. And one of the problems that we have quite often in a Chapter 13 is people fail to keep their attorney advised, hey, I need to modify this plan. I need to make it work. Sorry that I'm living on less income now, but I need the plan payments lowered from $300 a month to $100 a month. Plans quite often are modifiable, and the judge wants these things to work. Finally, keep in touch with your lawyer. Make sure that if you're in that Chapter 13, that your lawyer knows about problems if you have any whatsoever. This is Nick Thompson in Louisville, Kentucky. We're happy to sit down with you and plan your Chapter 13 or your debt settlement so that these things can work. Okay. And there's information on our website, on our web pages, and there's information in our manual if you care to download it and read it. Give us a call. Thank you.